Good evening, Mr. President and Mr. Arbitrator. My name is Mark, together with my co-counsel, Mr. Brandon. We are here representing our client, the appellant, Mr. Antonio Fortuna. I'll be speaking for 10 minutes, and I'll be reserving 1 minute for rebuttal. And the remaining 10 minutes, my co-counsel will be covering the issues 3 and 4.
Counsel, before you go on, can you just adjust the mic a little bit?
Yes, Mr. President.
Sure.
Yes.
Camera not on you. It's okay lah. Yeah, go on. Who's keeping time, by the way? Someone here.
Is it better now?
Yeah. Okay. Yeah, that's good.
So, members of the panel, the appellant has devoted his entire life for the game of football. A late bloomer by reputation, he trained relentlessly to earn hours of representing Iridonia in its 2026 FIFA World Cup qualifiers, a moment of immense national pride. He stands before this tribunal seeking nothing more than fairness. His statement of appeal was filed within the time, and a technical failure beyond his control should not deprive him of his access to justice. Now, for issue C, I shall now turn to my first submission, which is issue C. In our submission,
issue C is on.
Mr. President, issue C is on if appellant's statement of appeal is admissible.
Oh, that's issue A.
Oh, sorry. Apologies, Mr. President. That's issue A.
Sure.
I shall now turn to my first submission, and it is a submission that the statement of appeal is admissible for two reasons. First, the challenged decision with the grounds of the day itself of the receipt, and second, the appeal was laid due to a cyber attack which my client had no control over, and we have submitted Exhibit A, which is the email, which proves that the statement of appeal was filed on time. Now turning to my first argument, the statement of appeal was filed on the last day of 21 days deadline prescribed by Article 50, subsection 1 of the day of the FIFA statutes. The respondent argues that the day of the receipt is 31st March 2026, when the decision was fully upheld. We submit that the receipt is 2nd April 2026 because it is the day that the challenge decision was sent out with the parties background according to paragraph 23, page 5 of the record. Our first legal authority is the 2016 CAS case of Ivan Bilardo, where the panel at paragraph 75 held that the statement of appeal was admissible as the grounds of the appeal decision were communicated to the player on 22nd January 2016, and the player logged his statement of appeal on 12th February 2016, on the very last day of the 21-day appeal set by Article 67, subsection 1 of the FIFA statutes. Turning to our present case, if I may direct the panel to page 5, paragraph 26 of the record. At line 2, the challenge decision was sent out to the parties with the grounds on 2nd April 2026, according to Exhibit 7. And below, at paragraph 26, it states that on 23rd April 2026, the appellant paid a filing fee of CHF 1,000 and filed the statement of appeal. Therefore, the appeal was filed within the 21 days deadline pursuant of Article Rule 32 of the CAS Code, which expressly provides that the time limits are respected if communication is sent before the midnight, which was the last day in which such time did not expire.
Counsel, you are talking about the CAS Code. Earlier you mentioned Article 50 of the FIFA statute. So which one should I consider?
Mr. President, we would like to submit that Article 15 of the FIFA, Article 50 of the FIFA procedural code should be superseding in this case.
Okay.
Now turning to my second argument, Now turning to my second argument. The second argument is curing late deadline with Exhibit 8 email. The statement of appeal was not received by CAS due to an internal IT cyber attack which my client had no control over. And there is a case where the panel cured the late filing of the appeal when evidence was brought to show that the appellant had in fact filed the appeal on time. I would like to introduce the panel to the 2006-2013 CS case of AC Siena and Club Desportiva. At paragraph 39, the statement of appeal was filed 1 day later. However, the appellant submitted a shipment waiver as evidence that it had filed the appeal on the 19th by the Italian courier company.
Shipment waiver.
Shipment waiver, Mr. President. So it signified that the letter had already been sent to the courier company. It's the courier company which made the delivery late. So from the sender's point of view, they had already filed the submission. At paragraph 42, the panel held that the statement of appeal was timely filed and thus admissible. Now turning back to the present case, if the panel would turn to page 5, paragraph 31 of the record, particularly at paragraph 31, line 3, the statement of appeal was filed by an email specifically sent to the procedures at tas-cas.org at 23:45 hours Iridonian time, which was 15 minutes before the deadline, according to Exhibit 8. Now turning to issue 2, which was the appellant's refusal to hand over his mobile phone lawful.
Sorry, Counsel, can you address us on the late submission of your appeals brief?
Yes, Mr. Arbitrator. Mr. Arbitrator, we would like to submit that the delay of the submission was due to the cyber attack itself, and it is not fatal to our claim for 3 reasons. First, the cyber attack was unforeseeable, and it made it impossible for the appellant to comply with the stipulated timeline and deadlines. Second, the appellant does not bear any fault for the non-timely filing of the statement of appeal. And lastly, the request was shortly made right after the fact causing the delay.
No, I'm not disputing the fact that the cyber attack affected the statement of appeal. I'm asking about the statement of the appeal brief, which is the one submitted late in May, if I'm not wrong.
Mr. Arbitrator, it was only submitted 1 day late, and we needed that time to double check and verify whether the contents of the submission was correct and filed in the right manner.
Okay, so are you suggesting that it was because of the cyber attack? That's why your appeals brief is also late?
Yes, Mr. Arbitrator. This is exactly what we are submitting.
So just to help me a little bit, is there a difference between the appeal brief and the SOA, the statement of admissibility? Statement of appeal, sorry. Statement of appeal.
I'm sorry, sorry, panel. Give me 2 minutes. Mr. President, those 2 documents are two separate submissions, and both submissions were were submitted 1 business day late.
So these are 2 separate documents?
Yes, Mr.
2
President.
separate procedural requirements?
Yes, Mr. President.
And I can find them somewhere in the code?
Yes, Mr. President.
Okay, I'll take you up.
Okay, so I accept that the first statement of appeal is affected by the cyber attack, but I don't see how the cyber attack can affect the second one.
Mr. Arbitrator, I understand that my time has elapsed. If Mr. President and Mr. Arbitrator would allow me to...
I think we let them explore.
Uh, Mr. Arbitrator, I apologize. Could you please repeat the question again?
Yeah, I understand that the statement of appeal is affected by the cyber attack, but I don't see how the cyber attack affected the second appeals brief submission.
Mr. Arbitrator, it did not affect the second statement of appeal did not get affected by the cyber attack itself, and it was filed on a timely manner. Now, Mr. President, I understand I have elapsed my time, so if I could have 2 minutes to wrap up my second issue.
Yeah, sure.
Thank you. Now, moving on to the issue 2, which was the appellant's refusal to hand over his phone lawful. We would like to submit that according to Article 6, subsection 1 of the ECHR, it is fair, and the second is that there has been a violation of right under Article 6, subsection 1 of the Convention, which is not to incriminate oneself, and violation under Article 8 to the right of privacy. The European Court of Human Rights, now turning to the first, so talking more about Article 6, subsection 1, which is self-incrimination. We would like to submit that the duty to cooperate is not absolute. In our case, the respondent forced the appellant into handing his phone over on page 4, paragraph 21 of the record. The 1993 European Courts of Human Rights case of Feng and France at paragraph 44, the court held that an attempt to compel the applicant to disclose documents and thereby provide evidence of an offense has allegedly committed, violated his right to incriminate himself. Similarly,
I'm sorry, violated his right to incriminate himself.
Violated his right not to incriminate himself, Mr. President. Now, turning back to our present case, there is in fact a concurrent criminal investigation being conducted by the Iridonian public prosecuting authorities, and a valid claim by my client and appellant to refrain from delivering self-incriminating information. If the panel could turn to me to page 3, paragraph 13 of the record.
Paragraph
13, 1-3. At the top of the page, it states, and I quote, on 4th November 2025, the Iridonian Prosecutor's Office launched an investigation into the appellant and his father for sports manipulation. Here, the information obtained by FIFA could potentially be misused and be shared with the Iridonian public prosecuting authorities, and thereby we submit that the respondent violated my client's right to not self-incriminate himself under Article 6 of the Convention. Now, if there are any more questions by the panel, I would like to wrap up and submit my argument and hand my time over to my co-counsel, Mr. Brandon.
Yeah, go on.
Is there any grounds for you to argue that the Iridonian public prosecutor will misuse the evidence?
While there are no legal authorities on hand right now, it is a possibility that FIFA might share this information with the public prosecutors to potentially entrap and endanger the father and the son. So we would like to submit that it will cause an irreversible damage to Mr. Fortuna's case of manipulation. I would like to now hand my time over to my co-counsel, Mr. Brandon.
Sorry, before you do that, I don't believe you quite asked us or let us know what the sequence was. So the sequence is just going to be you and then your co-counsel, and then afterwards it goes to the respondent, or are we like...
I'm sorry, Mr. President, I was not clear earlier. So the appellant 1, who is me, and appellant 2, my co-counsel, Mr. Brandon, will be going first, and then the respondent 1, which is Mr. Austin, and respondent 2, which is Mr. Ramesh, will be going in the second.
Okay, and then the rebuttals will follow after that?
Rebuttals will follow after that, Mr. President, yes.
Okay, not after the same set of issues.
No, Mr. President.
Okay, understand.
I apologize for not being clear.
Can I confirm that the panel can hear me clearly?
I mean, perhaps a bit too far. But
Too far? Is this better? It's better now?
much better.
Mr. President and Mr. Arbitrator, good evening. My name is Brandon Zhang, appearing for the appellant on issues 3 and 4. I'll first make submissions on the admissibility of the anonymous evidence, followed by the submission on the violation of the Article 20 of the FTC. First, I will make 3 arguments on the first issue. First, CAS applies a strict safeguard to anonymous evidence. And second, those safeguards are not met in the present case. And third, alternatively, if they are admitted, the evidence cannot reach the comfortable satisfaction or has little to none evidentiary value. In the 2009 CAS decision of Karamudin versus FIFA, the panel made clear that anonymous evidence is exceptional and requires 4 requirements in order to be admitted. First, necessity, and then verification of identity by the panel, the ability to test the evidence through protective cross-examination and corroboration. We submit that the evidence, first, is not identifiable. In the Karamudin versus FIFA case at paragraph 188, the panel held that screenshot messages carries no evidentiary weight, even if there is a name attached to the screenshot because the appellant had failed to prove its authenticity. In the present case, the witness statement and the anonymous email, even if there was a name attached to it in the WhatsApp message, this has not been verified and therefore is not admissible.
I thought FIFA did say that you're talking about the screenshot, right, of the WhatsApp.
Yes, correct. And as well as the email evidence.
I thought FIFA did take steps to verify the anonymous evidence, or am I wrong on that count?
It is discretionary, and on the facts, the witness statement has, the witness in the anonymous witness statement has refused to identify himself, and this was on the record in the Exhibit 2 at paragraph 5. It says, I had no other choice.
Exhibit 2.
Exhibit 2, paragraph 5, and it says, my identity cannot be revealed. And the respondent may very well argue that it is allowed because there are threats of the appellant's father being engaged with criminal organizations, that snitches get stitches rule at paragraph 6 of Exhibit 2. However,
No, sorry, but so my question was, or rather my statement was, didn't FIFA verify his identity? If you look at paragraph 5 of Exhibit 1, I understand. I can understand that the witness had no other choice but to request anonymity. But if you look at paragraph 4 above, he or she did say that he was interviewed by FIFA. So isn't that some sort of verification process?
yes, Mr. President, in the alternative, we submit that even if verified, the ability to test the evidence through cross-examination has not been fulfilled. And this only pertains to Exhibit 2. There are still Exhibit 3, the anonymous email, and Exhibit 4, which is the WhatsApp message indicating the title, the syndicate, in its name, which hasn't been identified. Exhibit 3 is also anonymous tip email received, has not been forensically identified. Turning now to the second submission. We submit that there has been no violation of match fixing under Article 20 of the FIFA Disciplinary Code. First, we argue that there is a standard of proof of comfortable satisfaction pursuant to Article 39, subsection 3 of the FDC, and that has not been met. And second, that the Genius report raises suspicion but does not attribute manipulation to the client. And lastly, there's no evidentiary bridge showing manipulation under Article 20, subsection 1. In order to meet the comfortable satisfaction, there has to be evidence and not purely speculation. In the Genius reports raised, the respondent relies heavily on the Genius sports. However, as expressly stated in the Genius reports, there are rebuttable evidence. First, there are 3 goals, and the second and third goals expressly states that it is not due to individual errors. And the third goal, it was stated that resulted from a teammate's hamstring injury and was reported not a performance error.
I'm sorry, perhaps you could help us more if you referred us to the actual report.
Yes. Apologies, Mr. President. That would be in the Genius report. The pages are all numbered 8, but I believe it is at the fourth page on Exhibit 6. It's the 4th or 5th page, and they're all titled number 8 as an error.
So according to the electronic PDF that I'm looking at now, which I think you are looking at too.
Yeah, I think so.
Yeah, that's page 13 or 14.
Yeah, you did all title page 8.
Yes. Or maybe give us a phrase from that.
If you could just Control F goals. Comet Land's central midfielder collected the ball.
Central midfielder. Okay.
Central fielder collected the ball, and here it.
Sorry, hold on.
Yes.
Page 15. So somewhere along the end,
4th
64,
page.
04.
Yeah, it's just
64. Yeah, just search for central midfielder collected. I think we can read.
yeah, please continue.
Here it says at the last line, no individual errors were identified in the passage. At the next goal, line starting at the end of or beginning of line 4, Santiago pulled up with an apparent hamstring injury, allowing the forward to reach the ball first before converting the one-on-one opportunity past the Arizonian goalkeeper. While not a performance error, the inability of Santiago to continue his recovering run led to the goal being scored. And therefore, this does not prove that my client deliberately fixed the match due to his performance. And on the very last point, I know my time is coming to an end here. If I may, please direct the panel at this time to page 2 of the record at paragraph 2 of the record. On the 3rd line, is the panel with me?
Sorry, what? Which?
Page 2, paragraph 2 of the record.
Okay.
Starting here at the 3rd line, after the comma, replacing the team's captain and regular starting goalkeeper due to injury, he is considered a late bloomer. And therefore, we argue that any performance issues is simply due to the fact that he was a new goalkeeper for the team, replacing the original goalkeeper.
I don't quite agree, because what do you mean by new goalkeeper? Hasn't he been playing for some time? And I guess to be able to play for the national team, you should be able to be regularly playing for your club at the club level.
Yes, Mr. President. We would like to state that prior to this, he was simply a bench warmer for the team, and therefore he was only replacing the captain. And lastly, in my client's witness statement at Exhibit 6, paragraph 8 and 9, he was feeling sick before the match, consulted the doctor, and still chose to represent his country because of his deep passion and love for the game of football. And if there are no further questions, this brings
I'm so sorry to bring you back to paragraph 2 again, but it does say that he built a solid reputation in the last 2 seasons. So this suggested he played really well in the last 2 seasons, doesn't it?
Yes. However, this was a match in the qualifying games, and if the panel, Mr. Arbitrator, may look at the previous sentence in paragraph 4, its senior national football teams have never participated in a FIFA World Cup, and therefore the level of standard is much higher in the present case.
Thank you.
Thank you.
Good evening, members of the panel. My name is Seah, and I appear on behalf of the respondent, the Federation de International Football Association, FIFA. I'll be speaking on all 4 issues on appeal for 20 minutes, and I reserve 1 minute for my rebuttal. Turning to the first, members of the panel, substantive fairness is not the only issue here. Procedural fairness must be kept in balance. This panel has to simply decide whether an appeal that has been filed outside mandatory time limits is admissible, to which the answer is no. Furthermore, the appellant's claim against self-incrimination does not override the need to protect the procedural fairness and integrity of sport. With that, I turn to the first issue. We submit that the statement of appeal filed by Mr. Fortuna is inadmissible for 3 reasons. Firstly, the appellant had failed to meet the deadline of 23rd April to file the statement of appeal. Secondly, the remedy of reinstatement should not be granted to the appellant. And lastly, in any event, the appellant had missed the deadline to file the appeal brief. Turning to the first argument, I note that the appellant has raised the case of AC Siena and attempted to analogize it to a shipment waybill. However, the important distinction we must keep in mind is that a shipment waybill actually left the control of the appellant. In our case, the email had actually never even left the appellant's email in the first place. If I may direct the panel's attention to page 5, paragraph 29 of the record.
Okay.
The CAS office had yet to acknowledge receipt of the email and register the appeal. By operation of R31 of the CAS code, specifically relating to electronic filings made to the CAS, the filing is only valid upon receipt of the electronic mail by the CAS office. And this is further clarified by the 2022 CAS decision of Hungarian Football and FIFA, which held that such emails must enter into the sphere of control of the recipient. And as noted by Mr. Arbitrator in his question regarding the appeal brief, that brings me to my second argument. He rightfully pointed out that the appeal brief was submitted late, and this makes the statement of appeal not admissible. Counsel for the appellant has claimed that the appeal brief was submitted late because of the cyber attack that was faced by the appellant regarding the statement of appeal, but this is categorically wrong. If I may turn the panel's attention to paragraph 31 of the record, the counsel was able to send a separate email to CAS requesting for reinstatement, which means that on the 28th, their email servers were back to normal, and therefore, they had no issues regarding filing the statement of appeal on 5th of May, which was noted by counsel for the appellant to be manifestly late, and therefore, the statement of appeal should not be admitted. Unless I may be of further assistance on the first issue.
Sorry, just two questions.
Yes, Mr.
One
President.
is more general, one is more specific. So the first is this a matter of discretion that I have, or is it a strict rule I have to adhere to in terms of admitting the appeal? That's the first. So the more detailed question is, exactly what's the significance of the courier on 24th of April? I mean, if I had some discretion and it was just a few days late, and they did send the courier out the next day. So why can't I exercise my discretion if I have the discretion to admit appeal?
Certainly, Mr. President, I'll answer your question in two parts as you have phrased. With regards to the matter of discretion, yes, the courts do have this discretion and it's known as the doctrine of reinstatement. However, I will caution Mr. President on this issue as two previous CAS decisions, specifically the 2024 CAS decision of FC Football Club and the 2019 CAS decision of PFC and UEFA, the court demonstrated great reluctance against the remedy of reinstatement. However, they noted in extenuating circumstances, this discretion can be granted if two criteria are met. Firstly, the hindrance must not have been caused by the appellant, and secondly, the appellant must request for reinstatement promptly after the hindrance has stopped. And we contest the second element. If I may direct the panel's attention to PDF page 52, Exhibit 9, the last page, which shows the WhatsApp text chain between the counsel for the appellant and his IT support staff.
Right, okay.
Mr. Fortuna's counsel was informed of the cyber attack and its possible consequence on the 26th of April 2026. And yet, if I may direct the panel's attention back to PDF page 5, paragraph 30, they waited until 28th of April 2026 to request for reinstatement. The delay learning that the attempt had failed while short is inconsistent with the strict promptness standard required when dealing with pre-entry deadlines. And to answer Mr. President's second question, filing a courier is a requirement if you do file a statement of appeal via email. It's just a separate requirement to allow the statement to pass. And the discretion that Mr. President is concerned about should be focused solely on the email itself. And unless I may be of further assistance on the first issue, I'll turn on to the second issue regarding the handing over of the phone. We submit that the appellant's refusal and handing over of the phone is unlawful for two reasons. Firstly, the duty to collaborate was breached. Following Article 12 of the FDC, Section 3, persons subject to this code shall help to establish and or clarify the facts of a case or any possible breaches of the code, and in particular, and I quote verbatim, shall provide any evidence as requested. In the present case, if I may direct the panel's attention to PDF page 4, paragraph 20 of the record.
Sorry, page 24, is it?
PDF page 4, paragraph 20. Mr. Fortuna immediately refused to cooperate when FIFA's representatives requested that the appellant submit his mobile phone for the purposes of the investigation. And in the following paragraph, it showed that his refusal was sustained despite multiple requests, a clear violation of Article 12. And at this juncture, I note that counsel for the appellant has attempted to invoke Article 6 of the ECHR. While we do acknowledge that the right to a fair trial is applicable to our proceedings, the specific privilege against self-incrimination requires an extremely high threshold for it to be applicable to our case. And this was noted in the 2017 case of Jerome Velke and FIFA, where the only situation this privilege might extend to, and I quote, is when there's a clear and imminent danger that the privilege against self-incrimination will be circumvented. And the only way this will have existed is if there's a collaboration between the sporting organization and the public authorities in which both parties would share information, as noted by Mr. Arbitrator just now in his question to the appellant. However, the most crucial fact against this evidence of collaboration is that the Iridonia Public Prosecutor's Office explicitly refused to share evidence with FIFA, and this could be seen at PDF page 4, paras 15 and 16 of the record, where the prosecutor stated that they will only share information after the investigation was concluded and the case was ready for court. This refusal demonstrates that state authorities are protecting the integrity of their own criminal process and not using FIFA as an investigative proxy. I also note that counsel for the appellant has asserted that FIFA could possibly share information with the Iridonia Public Prosecutors, but this has been explicitly prevented against by the FDC. FIFA proceedings are confidential, and therefore FIFA will not be sharing information with the IPP, and this is noted by Article 53, subsection 7 of the FDC. Secondly, turning to the second issue of burden of proof, it is for the appellant to prove that there's an imminent danger that such right will be circumvented. And this was noted in the 2004 case of Maria Louis Kelly Williams. And on the facts, because it is unclear whether FIFA would share information with the case, this degree of uncertainty does not meet the threshold of clear and imminent danger. And unless I may be of further assistance on the second issue, I'll turn now to the third issue on appeal regarding the anonymous witness statements. Firstly, we submit that Article 6 of the ECHR is applicable in this scenario as it directly determines whether an anonymous witness statement or any anonymous evidence can be presented before the case proceedings. And it noted 3 elements required for reliance. Firstly, there must be a good reasons for non-attendance. Secondly, the evidence is not sole or decisive. And lastly, there are countervailing factors that safeguard fair assessments of reliability. And we submit that all 3 elements have been met with both regards to 2 evidence on issue today. In the case of Karimuddin, as submitted by counsel for the appellant, CAS accepted anonymity because allegations went beyond spotting misconduct and engaged serious criminal conduct, similar to our case. And the CAS held that this criminal environment and power asymmetry objectively heightened the risk of retaliation, even without the proof of specific threats. And the same structural features arise in our case. This case involves alleged sports manipulation, alleged criminal networks, and substantial cryptocurrency transactions. These are not mere disciplinary issues on appeal. Moreover, the alleged source of pressure is the appellant's father, described as a wealthy and influential businessman, as noted by the anonymous witness statement. As in Karimuddin, the power imbalance combined with the criminal allegations materially increases the risk of intimidation. And as rightfully noted by Mr. Arbitrator, the FIFA authorities had indeed interviewed the anonymous witness before, and to keep his anonymity to protect him from the possible allegations that the father is part of a criminal syndicate, they allowed his anonymity, and therefore they inherently confirm the reliability of the source of evidence.
Go ahead.
Can you address us on the appellant's point that there was no meaningful cross-examination? Because I believe in the case of Karimuddin, the court did call him as a live witness through an audio scrambler. Why can't this be done in this case?
Yes, Mr. Arbitrator, I note that in our case we did not have the same safeguards as provided in Karimuddin, but this does not discount the fact that the witness itself is clearly terrified of the appellant's father. Now, even if we were to impose the same safeguards that Karimuddin had imposed, it is still for the witness himself to determine to what capacity he wants to provide evidence to the court. If he does feel that such a safeguard is not enough for him, then clearly he should be able to provide the statement in itself without any cross-examination. And as further queried by Mr. Arbitrator just now, he has already been interviewed by FIFA, which already provides a layer of safeguard.
Sorry, I just want to clarify 2 things. You said that the father was wealthy. That's the first point. Can you point me to where exactly it says that he's wealthy? So the second point, you just said that we did not have those safeguards in reference to the audio scrambler, right?
Okay, you can continue your question first.
No, your question? Sorry, you were trying to clarify?
I was trying to clarify that that wasn't my submission. I was saying that even if we do have those safeguards, it is for the witness himself to determine in what capacity he wants to provide evidence to the court. Because even though you may have the audio scramblers, it is very possible that with the appellant's father's vast networks in a criminal organization, he's able to bypass these scramblers to possibly identify the witness. And to address the Mr. President's first issue, I heard in my submissions he's not wealthy, and it was a plain assertion.
I see. Okay.
And regards to the third element, the case has accepted reliance on anonymous witness despite the absence of direct cross-examination. And in CAS, they emphasize that internal consistency is a key mechanism. The panel assessed whether the anonymous statements were coherent, whether they acknowledged their own limitations, and whether they avoided exaggeration. And this is directly analogous to our case because the witness recounts a specific contemporaneous observation where he had a stress phone call the night before the match. And this can be seen in the witness statement located at paragraph 9 of the witness statement.
Sorry, which witness is this again?
This is the anonymous witness statement.
Okay.
Yeah. At paragraph 9, he expressly acknowledges the limits of what he could hear or know. And in Karimudin, the witness also did not speculate about betting or criminal arrangements, but confines the account to what was personally observed, and the internal restraint is precisely the kind of evidence that the CAS court would accept. And unless there are any further issues on the third issue,
Just go on.
I'll now turn to the last submission regarding Article 20. So the last issue asks whether Mr. Fortuna violated Article 20 of the FDC, and the legal standard and the method of proof as noted by counsel for the appellant is comfortable satisfaction, where it is higher than the threshold of balance of probabilities, but less than the criminal standard of beyond reasonable doubt. And there are 4 elements to be met to establish a claim of match manipulation under Article 20. Firstly, there must be an act or omission attributable to the appellant. Now, if I may turn the panel's attention to specific issues raised in the Genius report. Firstly, if I may turn them to the to the part that talks about the goals that the appellant saved or suspicious paragraphs. And this is located at the counsel will indulge me. PDF page 15 and PDF page 16. I'll be referring to these 2 pages concurrently. At the 23:21 minute, Fortuna attempts a lofted pass, which is misjudged and resulted in a goal. And secondly, a corner had passed through Fortuna's hands, which was noted to be an issue raised by the Genius report, which is an objective report. And these are acts and decisions in movements that directly shape the match events. Under the FK Pobeda Mosier, these all-field indicators do not need to prove intent alone, and they're evaluated alongside betting and off-field evidence to reach the comfortable satisfaction threshold. And turning to the second element, there was unlawful influence or manipulation of the cause that may result in a difference in the match. And what must be shown in this respect is that the conduct affected or was directed to affecting match sporting reality. And the match context makes this submission highly relevant, as Iridiona only needed a point to the top group, or even a limited loss to secure the second. And instead, Iridiona won 0-3, Combatland won 0-3, and the media harshly criticized Fortuna's performance. And the Genius Integrity Report concludes that the match may have been fixed after analyzing betting patterns and performance, and this can be seen at PDF page 15 at the bottom, where they analyze the betting reports.
15.
At the second last line, and I quote verbatim, as these statistics align with the pre-match betting expectations, no sporting mitigation could be applied to explain Combatland's rapid transformation into the betting favourite. And this brings me directly into my last submission, where there's an objective backbone that ties all of these elements together, the betting anomaly. Multiple bookmakers have reported unusual concentrated support for Combatland and market intervention. An offshore bookmaker had bet Combatland's pre-match after limits. Had bet Combatland pre-match betting, and after limits were kicked off, they returned and liabilities reached USD 500,000, and the bookmaker had to pull the plug around the 20th minute. Another crypto bookmaker noted that there was more Bitcoin bets on this match than all comparable qualifiers that day, and almost all bets on Cometland, and a new Iridium account had appeared to bet Cometland as well. Now, when we consider all of these betting anomalies evidence, together with the fact that the appellant played poorly right at the 20th minute when the betting markets were closed, it makes the rest of the strands of evidence, the performance influencers, the anonymous witness evidence, the anonymous email, cohere into a mosaic of evidence that establishes match manipulation. While counsel for the appellant has only alleged the inconsistency of one strand of evidence, this evidence must be seen in its totality to form the mosaic to establish that match manipulation did indeed take place. And unless I may be of further assistance on the last issue.
I do have some questions. Okay, so on the betting houses, so the report cites a few betting houses, right? If I'm not wrong.
Yes.
And they say they all point to the conclusion that there is some anomaly and which we could infer match fixing from. But how much weight can I put on them? Can I call them as witnesses before me? So that's one question I have. But maybe you can answer that before I go on.
Certainly. With regards to the betting reports, we do not consider them as an individual strand of evidence. In FK Pobeda, they analysed betting reports and other contemporaneous evidence that was provided, and this formed a mosaic of evidence. So as roughly pointed by Mr. President, we cannot rely on this singular strand of a betting report, although it may give objective evidence. However, taking in totality with the rest of the evidence, it is sufficient to reach the comfortable satisfaction threshold. And with regards to whether these bookmakers can be called in as witnesses or evidence, unfortunately, I am not able to advise on the issue.
Sorry, okay. Then I do have another question on Article 20. Perhaps a few actually. Could you find me the wording of Article 20?
Article 20 of the FDC, if I'm not mistaken, Mr. President.
Yeah, so are you there?
Give me a short moment. Yes, I'm there, Mr. President.
So anyone who directly or indirectly by act or omission, okay, fine, unlawfully influences and or manipulates the cause, result, or any other aspect. Could you help us with understanding this line? Unlawfully influences or manipulates. What exactly is that? Cause, result, or any other aspect of match seems to be broad. So, and I don't know if Tang over here has any other question marks on the wordings of this Article 20.
Certainly, Mr. President. I note that my time has elapsed. If I may have a minute to answer your question.
Sure.
So, with regards to the unlawfully influence and manipulates the course of the match, what must be shown is that the conduct affected or was directly or directed to affecting the match sporting reality was not simply because of poor play, but a direct act. And in our case, we argue that the goalkeeper's decisions that concede the opening goal and repeatedly cause danger are quintessential cause manipulation indicators, particularly when they align with the objective betting red flags. And if Mr. President could address me on the second question again.
Sorry, I addressed you on the second.
Oh, sorry, if you could, clarify the second question again. Which other line were you confused about, Mr.
No, I
President?
just wanted to understand just this particular Article 21, that's all. Unlawfully influences or manipulates, what it means. And then if you read on, it says the cause, result, or any other aspect of a match. It seems a bit broad to me.
And that's precisely the point, Mr. President. This article was meant to be brought to encompass all acts that are indirect or direct that can affect the course of a match to establish a match manipulation claim under Article 20. Noting that there have been many new cases of sports manipulation over the past 3 years, the FDC code, which was recently implemented in 2025, was amended to specifically include the wider ambit that Mr. President is questioning about.
Okay. Okay, then maybe I have one more question. So, where is the FIFA decision again? Okay, this is at exhibit.
This could be found on Exhibit 7, PDF page 40, Mr. President.
I do have some concerns about the scantness of the FIFA decision. So if we look at paragraphs 35, 36, and 37,
35, 36, and 37. Yes, Mr.
I
President.
think that's in page 48 of the electronic PDF. I mean, these are very scant grounds of decision, if I may. There's a lot of assumptions. So, for example, if you look at paragraph 35, it says, the player's father was involved with criminal organizations, and then I think there's a second one about Mr. Luke Fortuna at paragraph 36 had provided access. What does providing access mean? What can you possibly infer from him providing access? Wouldn't it be him actually complying with the authorities' request? He has nothing to hide. He just provides access. What can be made out of this?
I know that Mr. President has a few questions in that respect, and if I may take the time to answer all of his queries. So I'll answer your questions in a few parts. So firstly, you had queried me on the scanners of the report, and I do note that this FIFA appeal decision does not involve any case law, which is why I've supplemented my submissions today with the cases of FK Bobeda and Oryakov, which proves that a mosaic of evidence can be used to find a match manipulation violation. In regards to the fact that the appellant's father had provided access to his Dogecoin wallet, we're not contending that this is an evidence that goes towards match manipulation. Rather, this is, as rightfully pointed out by Mr. President, simply whether the appellant's father is cooperating with ongoing match manipulation investigations against him. Rather, the only strands of evidence I've been solely relying upon is the betting report, the actions by the appellant himself, and the Genius report that talks about how the appellant performed during the match itself. And therefore, with these strands of evidence, it is sufficient to form a mosaic of evidence to find a violation of Article 20 of the FDC.
Yeah, but there's still a gap, you see, because the payment is paid to his father and not him. Like, do you have evidence to suggest that his father had control over him?
On the facts of the case, we are not sure, and the only thing we do have is a contemporaneous witness statement that shows the anonymous witness hearing that there was a conversation and that the appellant claimed that he couldn't go along with the father and everything. And while that in itself is not evidence of any ongoing ties between the appellant and the father with regards to a match manipulation claim, we do need to take this evidence as a whole with what we have seen so far. The fact that the appellant played poorly at the 20th minute juncture when the market has closed. Furthermore, the other areas of interest where the appellant himself had performed well towards the end of the match, but at the start was conceding goals like nobody's business. So, taken as a strand of evidence, we will agree with Mr. Arbitrator that it is not enough. But if we take a look as a whole, all the evidence comes together to show a match manipulation violation.
Okay, then maybe humor me in terms of the interpretation of that phone call.
Okay.
Because one can say that he was stressed and he refused to go along with his father, or one can also say that he was pressured and he eventually succumbed. And then you say that, it is the later interpretation, which is, he succumbed to pressure from his father, and that's why he performed badly in the first, we were saying 20 minutes, right? But it seems like it's built, what you're arguing is built on assumptions and assumptions and assumptions, which makes me not very comfortable.
I see.
Yeah, to say, that this is really evidence of his.
I understand, Mr. President, but not to sound repetitive in this respect, but to keep in mind the framework of a mosaic of evidence. So we do acknowledge there can be multiple interpretations of the phone call. It could be simply that the appellant was worried about the match and he was maybe expressing to his father, I'm worried about the course of the game and everything. But when we consider that the phone call, which took place right before that very match, that all of this match manipulation claims has started, and the fact that just 20 minutes after that phone call was when all of the betting reports start to go to the other side, because Iridonia was the favourites to win, and yet Combat Land at the 20th minute mark started, betting reports for Combat Land itself started shooting in the opposite direction, and this was directly timed with the appellant's actions on the field. So you could easily classify that as, when looking at the evidence as a whole, that the appellant finally gave in to his father's demands to say, finally, you know what, I will help you with the match manipulation claims, and ultimately he did so, which allowed the markets to turn in favour of Combat Land.
What about a third interpretation? Mr. Fortuna, basically upon pressure, having pressure from his father, refused to comply with his needs, but he didn't play horribly for the first 20 minutes because he wanted to. Maybe because of whatever conversation he had at that point in time, and then he had pre-match jitters of 20 minutes. Then I think after 20 minutes he did not too bad, right? If I'm not wrong.
Mr. President, if I may direct you to another strand of evidence in that respect, because counsel for the appellant has raised the fact that the appellant wishes not to incriminate himself by refusing to hand over his mobile phone. And that begs the question, if the appellant had truly nothing to hide in his relations with his father, why would he be raising a claim against self-incrimination? And therefore, his refusal alone can be used as an adverse inference under Article 9, subsection 6 of the IBA rules to find that his refusal can be used as adverse inference to find that he did indeed conspire with his father.
Okay, I hear you on the IB rules, but are we bound by IB rules in this instance?
While you are not bound by the IBA rules in this instance, multiple case decisions prior to this, such as the 2004 case of Murray Kelly Williams, noted they were persuasive in the fact that they do provide clarifications on areas where the case rules are silent upon, and adverse inference is one such instance.
What is the threshold to meet before I can make an adverse inference?
If I may provide Mr. President with the exact wording of the IBA rules.
Oh, that'd be great.
So the exact wording is that the tribunal may draw inferences that are adverse to the defaulting party should they, and I quote, refuse to produce any other relevant evidence that was requested by the party or ordered so by the tribunal if the party fails to provide any satisfactory explanation. And as established, Article 6 of the ECHR is not applicable in our case, which means that there's no satisfactory explanation for why counsel for the appellant refused to hand over his phone, and therefore you are able to use the doctrine of adverse inference.
Okay. Nothing further from me.
Thank you, members of the panel.
Mr. President and Mr. Arbitrator, 2 points in rebuttal. The respondent has argued, I quote, Article 6 is not applicable and that the refusal of the mobile phone can be used as adverse inference, and also submitted that the Exhibit 2 was reliable, and we argue this is incorrect. First, on the evidence, this is strictly double hearsay at paragraph 6. These are rumors that the father is involved with a criminal organization. Therefore, it is an anonymous witness statement who has not been cross-examined and also heard something that was to be rumors. And on the second point, on the applicability of Article 6, in the 2018 European Court of Human Rights case, Mutu and Pechstein versus Switzerland, this was a cast decision that was overruled, where the panel held that the Article 6 was applicable because the athlete faced a sanction of 5 years for doping, and that it falls under the civil head of the claim. In our case, it is also applicable as the civil head. In that case, it was held that it was under the civil head because it affected the athlete's right to occupation. It also affects my client's right to occupation. And lastly, in the 1993 ECR case of Fouquet versus France and the 2001 case of JB versus Switzerland, the European Court of Appeal held that compulsory acquisition of evidence is a violation of Article 6, subsection 1, not to self-incriminate, and the right to privacy under Article 8. In the present case, this would be a violation for the refusal to submit a mobile phone under Article 6 and 8. Unless I may be of any further questions.
Yeah, I'm so sorry for harping on this once again. Can you please address us once again on your late submission of your appeal brief? Because I'm sure you agree with me that this is very important, because under R51, if you do not submit your appeal brief within 10 days following the expiry of the time limit of the appeal, your appeal is deemed to be withdrawn and you submitted it on the 12th day.
May I ask Mr. Arbitrator which specific paragraph?
Yeah, so if you look at paragraph 33, it says, or page 6, paragraph 33, it says on 5th of May 2026, you filed an appeal brief before the CAS. And the appeal deadline is on the 24th, 23rd, 33rd, or 24th of 2026. So the difference between that is 12 days, and that is more than the 10-day limit.
Yes, Mr. Arbitrator. The limit is 10 days.
Yeah.
And we argue that it should be admissible because one of the days is a Sunday. And therefore, technically, only one business day it was not filed. And under Swiss law, generally, solicitors are obligated to check their emails once every business day. And therefore, we argue that it is reasonable that it was checked, and also the context was looked at and prepared given the time limit and the overall circumstances of the case. This brings me to the end of my submission.
Sorry, just one question. I heard you say the case of Mutu Pechstein was overruled by who?
By the European Court of Human Rights. It was a CAS decision.
Okay.
It was a CAS decision. They held that Article 6 was applicable under civil head of Article 6.
Members of the panel, 2 points in Sir rebuttal. Counsel for the appellant has mischaracterized my argument. I did not say that Article 6 of the ECHR is not applicable in our case. In fact, I did say that it was applicable regarding the third issue regarding the lawful handing over of evidence. However, the specific privilege against self-incrimination is a speciality of Article 6 of the ECHR, which demands an extremely high threshold of clear and imminent danger, of which that was not met in our case. And secondly, he has alleged that the duty to cooperate should not be followed in our case because it is absolute. However, it is not absolute. We do agree that it's not absolute. It's merely a general duty as noted in the 2022 FIFA appeal decision of Chilean Football Association. However, we have to understand that the FIFA committee is not an investigative authority like the Iridonia public prosecutors who can demand evidence as and when they wish, and they would so in case of a criminal investigation to request for handphones. However, if FIFA only operates in a civil manner, in which case they rely on the cooperation of its members to help and aid in their investigative processes. And while we do note that this is not an absolute duty, this is the only way they are able to procure evidence, and we will submit that this duty does extend to the appellant to provide his mobile phone.
But this is an arbitration, right? So I'm sure in Switzerland or Iridonia, I don't know if Iridonia is part of the New York Convention or what, but aren't they, if they are, can't FIFA, to facilitate this arbitration, request for interim aid or reliefs from Iridonian public authorities for whatever evidence they can have? Can't they make that official application through their government channels or whatnot?
Well, I do note that if I may turn Mr. President's attention to the facts, actually, the FIFA had requested for the Irregular Public Prosecutors to provide them some evidence with regards to the case, and this can be found at page 15 and 16 of the record. Paragraph 15 and 16 of the record at page 4. Where at paragraph 16, they explicitly stated that they could share no information other than what they had already disclosed to the media. So this directly goes against the claim that the Irregular Public Prosecutors would aid FIFA in the investigations, and therefore they're left alone by their FIFA disciplinary code to request for their members to cooperate in investigations, such as in producing evidence. Thank you, members of the panel.